gave a speech where he mentioned that the scheme that has been launched by the government, is against the fundamental rights it's violating the fundamental rights of environment and of the tribal people as well. And after that, he was being implemented. After that, Section 150 FIR was launched against him, and he was charged of Section 152 of the PNS. And then he approached the Honorable Supreme Court challenging the constitutionality of Section 152 as well as the scheme that is in the question in the present case. The Council seeks permission to address the fourth issue. Your Lordship, the fourth contention which the Council has tried to put forth in this particular issue is that Section 152 of PNS is imprecise and vague. Your Lordship, any law which is not clearly defined or is subjective in nature is said to be vague. Vague laws fail to give individuals a clear meaning of what exactly is legal or what exactly is illegal. This ambiguity and uncertainty undermines the principle of legal certainty. Here in the present case, the Council's contention is that Section 152 of PNS is also vague in nature. Your Lordships, kindly refer to the flag 25 of the compendium, where the case of Shreya Singhal versus Union of India is mentioned. In that case, Section 66 of an IT Act was struck down just because it was violative of Article 19, Clause 1, Subclause A. Moreover, it was vague in nature.
Or 67, IT Act.
Your Lordship, Section 66. The Council has stated that on the Your Lordship, in that case, the Section 66 was struck down because that was violative of Article 19, Clause 1, Subclause A of the Constitution, as well as it was vague in nature. And the words that were vague, it also stated that what were the words that were vague in nature. The words like grossly offensive or menacing are so vague that there is no manageable standard by which a person can said to have committed an offence or not have committed an offence. They are so subjective in nature that it is difficult for a person to contend in whether they are doing it will incite a criminal offence or would not incite a criminal offence. And hence they were contended as vague. And in the present case also the Council's contention is same. Section 152 of PNS uses broad and ambiguous terms such as subversive activities, succession, and encourage feeling of separatist activities. These terms lack precise definition of exactly what could be interpreted behind this word. There can be multiple interpretation, multiple ways, as these words are subjective in language, and hence they are considered vague in nature as well. Moreover, Lordships, the law uses words like excite or attempts to excite rebellion, which blurs the line between protected free speech and illegal actions. This could lead to punishing individuals for merely expressing their opinions or ideas that, while controversial, are not directly inciting violence or rebellion. In essence, any criticism of government is made punishable, the effect of which on the audience depends on the intellect capacity of the viewers, and it may or may not constitute the crime depending on the intellect of the audience. Furthermore, due to the vague nature of Section 152 of PNS and the broad nature, the law could have a chilling effect on the free speech, as individuals may refrain from expressing their views in the fear that their speech might be interpreted as a criminal offence. This could stifle public discourse and debate, which are essential for a democratic governance. Hence, it is humbly submitted before this honourable bench that Section 152 of PNS is imprecise and vague. Now, if the Lordship doesn't have any further queries, the Council would like to call upon my co-counsel to deal with the issue.
Council seeks permission to approach the case.
You are not responding?
I am dealing with issues and I am dealing with the third issue, second issue. As my co-counsel has dealt with issue 1 and issue 2. As my
Which issue you are dealing with?
issue 2, no.
Issue number 2.
As my co-counsel has dealt with issue 1 and issue 3, I shall be dealing with issue 2. Issue 2. Whether the environment will prevail over right to carry, trade, profession, or occupation, or vice versa. It is most humbly submitted before this honourable bench that any kind of development or industrial project cannot come at the cost of depriving someone's life. Your Lordship, right to life under Article 21 includes right to environment. Therefore, depriving a person of his right to clean environment by introducing such a scheme would be violated of his fundamental rights. Herein, the arguments have dealt on 4 grounds. That is, the ground 1, that the right to life and personal liberty also includes right to wholesome environment. Ground 2, that this scheme is violating the principle of sustainable development. Ground 3rd, that the right to profess trade, profession and occupation is not an absolute right. Ground 4, that the public trust of doctrine is being violated. Ground 1, that the right to life under Article 21 also includes right to wholesome environment. Article 21 of the Constitution of Federal guarantees that no individual shall be deprived of his life or personal liberty. In the case of Maneka Gandhi versus Union of India, it was clearly held that procedure prescribed by law has to be fair, just, reasonable and not oppressive, not fanciful. Your Lordships, the right to life is not confined to mere physical or animal existence, but includes right to every limb through which life is enjoyed. Your Lordships are humbly requested to kindly refer flat 19 of the compendium in the case of Subhash Kumar versus State of Bihar. Is the bench with me? In the case of Subhash Kumar versus State of Bihar, this very bench has held that pollution-free water and air are essential for the enjoyment of life and personal liberty. The right to life under Article 21 implicitly includes right to healthy environment. Your Lordships, the word life under Article 21 means a quality of life which includes accommodation to live in, right to food as well as right to wholesome environment. Your Lordships, in the case of Vellore, your Lordships are humbly requested to kindly refer flag 24 of the compendium. Indeed. In the, your Lordship, in the case of, shall I proceed? In the case of Vellore Citizen Welfare Forum versus Union of India, it was held that though the lead industry is of vital importance to the country as it generates foreign exchange as well as employment revenues, but it has no right to destroy the ecology, to degrade the environment or pose any kind of health hazard. But your Lordship, in this present case, the fast and safe transport scheme introduced by the government of Fedule involves the extensive use of forest as well as tribal land, as it has been very clearly mentioned in the mood proposition. That it requires 9,800 acres of land, that is the tribal as well as the forest land. Your Lordship, this scheme has raised the concerns regarding the impact on the environment, biodiversity as well as the livelihood of the indigenous people who are living on those land. Your Lordship, for tribal peoples, the natural resources like air, water or other natural resources are not mere natural resources. For them, it is kind of sacred entities. This large-scale project, without adequate environmental safeguards and assessments, infringes right to clean environment of the people of Aryavarta, which is an implicit right under Article 21 of the Constitution of Federal. Your Lordships, ground 2nd of this issue, the Council has contended that the scheme violates the principle of sustainable development. There should be a harmonious coextensive between the nature's bounty and the mankind's development. Your Lordship, it should never be forgotten that man only holds a leasehold right on this earth, but future generations should not be deprived of the pristine glory of the earth. Basically, any kind of development or industrial project should not come at the cost of environment. Development projects should adopt mitigating strategies before receiving the approvals from the indigenous tribes. In the case of Orissa Mining Corporation versus Ministry of Environment and Forest, it was held by this very bench that right of Dungaria tribe, Kond tribe, to decide whether or not the bauxite mining should be implemented or not, should be applied on their sacred hills. The court ruled that development cannot proceed without the approval of the affected indigenous tribes. Your Lordships, similarly in the case of Goa versus Diksha Holding Private Limited and others, it was held that no activities which would ultimately lead to unscientific and unsustainable development and ecological destruction should at all be allowed, and the court must scrupulously try to protect the ecology from degrading as well as the environment. The true development and should aim to provide quality of well-being of the people. The concept of sustainable development is to be treated as the integral part of Article 21. Moreover, the legislative intent under and the spirit under Article 48 capital A and 51 capital A subclause G has been defined in the Environment Act of the Environment Protection Act 1986. Your Lordships, in the present case, this scheme introduced by the government of Figure involves the significant infrastructural development project in the state of Aryavata, which degrades ecological richness, including the forest, are at due risk, as it has been very clearly mentioned in the moot proposition that it requires 9,800 acres of land, which includes forest land as well as tribal land. Due to this scheme, the serious threat to the environment and biodiversity has been generated, and indigenous community rely on the tribal lands for their livelihood, which is being violated. Your Lordship, this scheme favors economic benefits as well as economic benefits over the environmental conservations and the well-being of the people. Hence, it could be humbly submitted before the Honourable Bench that principle of sustainable development is being violated. Your Lordships, the third round of the third contention, the third round of the council is that the right to life, that the right to practice any trade, profession and occupation is not an absolute right. Under Article Clause 1, Subclause G, right to practice any profession or carry on any trade has been granted. However, this right is not an absolute right and is subject to reasonable restrictions imposed under Article 19, Clause 6. Your Lordship, the government may place restrictions in the interest of general public and or to protect the public health, morality or safety. Your Lordship, the laws protected by Article 19, Clause 6 are regarded as valid even though they infringe upon the fundamental rights under the Article 19, Clause 1, Subclause G. If the legislation seeks directly to control the citizen's right under Article 19, Clause 1, Clause G, its validity has to be tested in the light of the provisions that are contained in the 19, Clause 6. Your Lordships are humbly requested to kindly refer flag 23rd of the compendium. Is the bench with me?
These are not complete for the
Pardon?
These are not complete.
Pardon, Your Lordship. In the case of T.N. Godavarman Tirumal Park versus Union of India, it was held by this very bench that environment must be prioritized and any economic activity or industrialization project that causes significant harm to the environment should be restricted. The Supreme Court has emphasized the need to balance between development and environmental conservation. Your Lordships are humbly requested to kindly refer to flag 21 of the compendium. Your Lordships are humbly requested to kindly refer flag 21 of the compendium. As
Yes, proceed.
in the case of MC Mehta versus Union of India, it was held that economic or right to trade cannot override environmental concerns when the two conflicts. Your Lordships, here the restrictions were placed on the industries to prevent the pollution around the Taj Mahal, emphasizing the trade must operate within the guidelines of environmental laws. Your Lordships, in this present case, the environmental protection, public health and the preservation of the biodiversity are the legitimate grounds for imposing restrictions on the economic development projects under Article 19, Clause 6. Consequently, the government's right to implement fast and safe transport scheme should be subject to these reasonable restrictions in the interest of protecting the environment and rights of the indigenous tribes. Your Lordships, round 4, that is, the doctrine of public trust is being violated through this scheme. Your Lordships, the doctrine gives state control over common public resources in a manner which furthers preservation and protection in the interest of public interest. The doctrine of public trust holds that certain resources like air, water, forest and other natural resources are meant for public use and controlled by the government in a manner that not harms the public interest as well as do not exploit the natural resources. But Your Lordships, in this present perform its duty as a trustee of these resources. Another important fact of this doctrine is that it limits the states from excessive entrustment of natural resources and natural public resources to commercial entities. Your Lordships, the contemporary concern about the environment bear a very close conceptual relationship to this doctrine. In this present, the government, in introducing this present scheme, has played its role as a protector of these resources by prioritizing development or other interest or environmental concerns and protection and sustainable use of resources has acted the trust placed on it by the public. Hence, the doctrine of public trust is violated. If Lordships do not have any further queries, Council would like to proceed with the prayer. Prayer. Therefore, in the light of issue raised, argument advanced, authorities cited, it is most humbly and respectfully prayed before the Supreme Court that it may be pleased to adjudge, hold and declare that the current petition filed is maintainable and that the issue of to issue the writ of mandamus restraining the implementations of the Fastex project, that the issue to writ of certiorari adjudicating the validity of section 152 of PLS and pass any other order, direction or relief that it may deem fit in the best interest of justice, conscience, as well as both conscience and fairness. For this act of kindness, the petitioner shall be duty bound forever to pay. It is honored before our reading.
Before we consider your prayer, can you tell us one thing? Right to environment and right to trade, they are two distinct rights. Is it necessary one should prevail one upon the other? Can it not be harmoniously construed?
Your Lordship, we are agreeing with this point, but in the present scheme, the current government of Tribunal has tried to override the fundamental right to life of the tribal people by just imposing this scheme and initiating few of the steps that are very clearly mentioned in the new proposition without having any kind of sustainable development, without having any kind of surveys that are being conducted by the NGT National Green Tribunal as well. Lordships.
Council seeks permission to approach. Council seeks permission to speak without much approach. Your Lordship, there are two compendiums. The white page is the compendium, Your Lordship. There is two copies of the compendium. We are not allowed to say the name, Your Lordship. We are the team code 107. Much of it. Lordships, the cover red, that is the pleadings of the respondents. The cover white are the compilation of the cases which the council will refer in the proceedings.
This is the
Immediately.
half parts is minus, half parts is plus. Yes. So for this one,
Indeed, Your Lordship. This is the council for the respondents. Council will speak for 30 minutes on issue A and B as given in the moot proposition. The co-council will speak for 20 minutes on issue 3, Your Lordship. That is C, mentioned in the moot proposition.
the Lordships,
If Your Lordship may refer to para 12 of the moot proposition, it is not contended that a single PIL has been filed. Same has been accepted by the petitioners, Your Lordships. In the present case, the two contentions in the PIL is first the environment, the order which the government passed for the development scheme. Second is the constitutionality of section 152, Your Lordship. If Your Lordship may refer to page 79, para 53 of the compendium, Your Lordship. Your Lordship, I'll read the para for the sake, Your Lordship. It defines PIL, Your Lordship. PIL means a legal action initiated in a code of law for enforcement of public interest or general interest. Your Lordship, public interest or general interest, in which a public or a class of community have pecuniary interest or some interest by which their legal rights or ability are protected. Your Lordship, you are well aware that in Your Lordship code, local standard is more prominent than merit of the case in the first proceeding, Your Lordship. Cases, SLPs, appeals and writ are dismissed in a minute or two if the council have failed to provide the local standard, Your Lordship. In the present case, such PIL which are personally motivated if your lordship may refer to page 18, para 109, it states, the Honorable Court cautions that a person pursuing personal gain, political motive, or any extraneous considerations under the guise of PIL has no local standard. In the present case, your lordship, the petitioner, as of the date, is behind the bars, your lordship. He is not innocent, he is not accused, he is guilty, your lordship. Session Court have accused him under section 150, your lordship. The mens rea and actus rea of his act are being established in the Session Court, your lordship. The petitioners have stated again and again that protest was lawful, your lordship. However, a provocative speech was given by the petitioner and casualties and public damage happened in the present. Your lordship may refer to para 9 for the same, lordship. It is clearly mentioned that due to this speech and pledge that was taken by the petitioner, Elon Musk, who is behind the bars, your lordship, has led to a furore that caused casualties and harm to the public, lordship. If your lordships, such practices where his personal interests are guised under PI lordships, no other person has been any other person's liberty has been curtailed by section 152 in the present case, lordships. It is only Elon Musk. What he did not go to appeal, your lordships, to question the decision of Session Court, lordships. This led to the presumption that he is guilty, your lordships. And what he does is goes to the Honorable Court and asks for the constitutionality of section 150, lordships, where they have failed to summarize why they have come to the court, lordships. In the oral pleadings of the petitioner, they did not argue why the section 152, the constitutionality of section 152, stand before your lordship. That's why your lordship is such practice. Getting behind the door, getting here by the back door in front of your lordship is not accepted, and it is against the spirit of a public interest litigation, lordship. It is a personal interest litigation in the present case, lordship. And in the case of Kusum Lata versus Dino Napiga, your lordship will find in a separate document, your lordship, in that. It is stated in the petitioner in the present case, lordship is a tenderer who questions the tender process in the High Court, your lordships, through a PIL. High Court dismisses the PIL on the grounds that the petitioner has some interest in the PIL. She is the tenderer, and the second petition where she questions the auction, she is the party to the auction, lordship. And the High Court dismissed the PIL. The matter went to the Honorable Court in appeal, and the Supreme Court held that the High Court did right in dismissing the petition, your lordship, the public interest litigation filed by the petitioner, as it was not a public interest litigation but a personal interest litigation, as the same stated by the High Court, your lordship. Therefore, they are not allowed to stand before your lordships for the constitutionality of section 150, your lordship. And your lordship, the second part, that is the environment part, counsel will deal with the same now. Your lordship may refer to page 55, para 40 of the complaint. It is Bhopal Gas Pedit Mahila Udyog Sangathan and others versus Union of India. Your lordships, it is categorically stated that environmental issues covered under NGT Act must be instituted and litigated before NGT. Lordships, respondent humbly accept that the Honorable Court has jurisdiction to try any and all cases in the territory of our lordships. However, the court are already overburdened. NGT, National Green Tribunal, is established to help the Honorable Court for the same lordships. Section 14 of the NGT Act provides that all cases has the jurisdiction in all cases concerning environment and hampering of legal rights, your lordships. The petitioners have mentioned Forest Right Act of 2006 for the tribal rights. Lordships, those are not fundamental but legal rights enshrined in the statute. Therefore, they did not have exhausted the alternate remedy, which is
what is 14 of
NGT Act. Your lordship, it is there in the complaint. It states that they have power, or the NGT has jurisdiction to track all of the environment cases. Even if your lordship, section 16 provides that appeals can be filed against order of Ministry of Forest and Conservation, where they feel that environment harm will occur due to those orders. Section 20 provides that the NGT should follow sustainable development principles, precautionary principles, and polluter's pay principles. That in length has been argued by the petition, your lordship. Therefore, the NGT is better equipped to deal with these cases, your lordship. And same has been stated by Honorable Court in Bhopal Gas Pedit Mahila, as expert body, the NGT, have experts as well as judicial members of the case, Your Lordship. They are better equipped to try the case, and if Your Lordship today allow this petition to be accepted, Your Lordship, in future any of the member of the country will come to the Honorable Court in PIL asking that my fundamental right, that is environment, be accepted. Article 21 entails right to environment, Your Lordship. Anyone will come to your Honorable Court and say my fundamental right has been violated under Article 21 as it protects environment. Your Lordship, it is a court judgment, any full judgment, that is true judgments of the Honorable Court, will have to accept those petitions, public interest litigation, as they are bound by your Honorable Court's decision, and this will render the NGT Act, Your Lordship, without teeth. It will the petitioner, the respondent cannot argue that they have not exhausted the remedy, Your Lordship, as a better and effective remedy is provided under NGT Act, Your Lordship. Therefore, this petition should not stand today before your Honorable Court, Your Lordship. If Your Lordship are pleased, the Council seeks permission to begin with the submission of issue B, Your Lordship. That is where the right to environment will prevail. Your Lordships have heard in length about the sustainable development and other doctrines by the petitioner, Lordship, and the question arises that can there be development on a such rich biodiverse land, Your Lordship, and were the tribal rights were heard in the present case, Your Lordship. The Council seeks permission to state facts of a case named Conservation Action Trust versus Ministry of Environment, Forest and Climate. Your Lordship, it is a 2023 decision and it is being debated till date, Your Lordship. It is by the NGT, Your Lordship. And the facts of the case are the petitioner. If Your Lordship may refer to page 26, para 7. Lordship, the appeal has been mentioned that why the appellants came before NGT. Lordship, the appellant stated that it is Andaman Nicobar case, Lordship, where the development is to be occurring Andaman and Nicobar Island, which is also very high rich biodiverse land. They say that the land has tropical, subtropical forest, habitat of turtles, and birding nesting grounds, which will be hampered. Further, Your Lordship, PVTGs, that is the Council seeks permission. Your Lordship, scheduled tribes and the particularly vulnerable tribal groups are situated in the Andaman and Nicobar, and the same development will hamper these rights. The National Green Tribunal went in length and heard all the arguments of respondent petition. It is a very lengthy judgment, Your Lordship, and all the cases which the learned petitioner have argued since 1960, which is Indian Agro-Legal, the MC Mehta case, all has been considered by the NGT, Your Lordship, and the same has heard by the respondent, Your Lordship. And they allowed the development. Lordship, for context, in the present case, 9,800 acres of land is being acquired, Your Lordship, or is being acquired for the development project, which turns out to be 30 some square kilometer, Your Lordship. In this particular case, Your Lordship, 130 kilometers square of land was acquired of Andaman and Nicobar Islands, Your Lordship. Furthermore, Your Lordship, the laws of Fagul are perimeter to laws of Republic of India. However, geography of Fagul is not same as geography of India, Your Lordship. Same has been provided in the clarification number 22. Therefore, Your Lordship, northeast of India is not similar as northeast of Fagul, Your Lordship. Therefore, 9,800 acre of land cannot be compared as to what is the boundary of Aryavata, Your Lordship, and how much land is being acquired through this process of development, Your Lordship. Furthermore, Your Lordships, all the cases as mentioned are discussed in that case, Lordship. The Honorable National Green Tribunal cited that the development is substantial in nature, is sustainable in nature, and the economic interest that it will provide in the sea, Your Lordship, the Andaman Nicobar Sea, it will create jobs, it will create economic development for the whole of the nation. That is why it is imperative for the development plan to go ahead, Your Lordship. And Your Lordship, the petitioner in the written submission in the citation number 48 cited the Rajiv Suri case, that is, Your Lordship, the new parliament building case, Your Lordship, of 2021. Your Lordship, in that case, the Honorable Court in a 3-judgment decision allowed the building of the development of the building of the new parliament, Your Lordship. Therefore, with the citation of that case, Your Lordship, the council for the petitioners have tried to mislead this court that such decisions are being made in their favor. If Your Lordship may refer to page 6 16, para 520. If your lordship may kindly refer to that. It is the Rajesh Suri case where it is categorically stated that the sustainable development is a doctrine of development, your lordship. It is that the development should be in compliance with the environment, your lordship. In the present case, lordship, all the permits have been acquired. The council will elaborate on the permits that were given. If your lordship may refer to page 28, para 10 of the compendium, your lordship's compendium, the council of the compendium. Lordship, the permits that were given, the permits are given after the environment impact assessment. They are given after social impact assessment. Your lordship, a particular committee for the tribal rights it is mandated to be constituted, and before the permits are given, your lordships, this is the Ministry of Environment Forest notification of 2006, which says that certain projects are bound that are required prior environmental clearance, your lordship. In the present case, the development are in 9,800 acres, your lordship. Therefore, they fall under this Schedule A of the same notification. If your lordship requires, the council will submit the notification. It is required by the joint committee that will require the environment clearance, your lordship. In the present case, the new proposition 6 states, 7, 8, your lordship, that states all the permits have been acquired and they will adhere to all the guidelines to minimize the environmental impact, your lordship. Therefore, as the Honorable Judge has pointed out, at a balance is being conducted, is situated in the present case between development and environment, your lordship, as all the due procedures have been followed, your lordship. Furthermore, your lordship, the council will submit why the project is sustainable in the present case. Your lordship, the council for petitions have in length talked about Article 19 and 21, your lordship. Lordship, it is only stated that right to development is also a part of right under Article 21, your lordships. And same is to be balanced here in the present. Also, Article 21 is again not absolute. It is curtailed by the procedure established by law, your lordship. In the present case, the procedure has been followed, and it is not the contention of the petitioner or in the present case that the procedure was followed accordingly or not. It is a presumption of law that the procedure is lawfully followed in the present case. It is the PSA or the Evidence Act or the News Sanhita that says there is a presumption of law that the acts of government are lawful in the directly the prime facie. Furthermore, your lordships, Article 19(1)(e), that is right to settle and reside in the country of our lordships, again is not absolute, your lordships. It is curtailed by this Article 19 subclause 5, your lordships. That is again in the public interest. In the present case, your lordship, it is not the development of Aryabhatta only. It is the development of whole country, your lordship. That economic boost will help all the citizens of the nation of our lordship, not only the nation or not only the state of Aryabhatta. It is mentioned in the para 8 of the Mood proposition that the development plan will help to increase trade, occupation and profession throughout the country as the connectivity will increase, and the same is being for the whole of the country. Furthermore, your lordships, in the present case, doctrine of margin of appreciation is applicable. Your lordship, this doctrine is of European Committee, your lordship, and if your lordship will refer to page 87, para 75 of the compendium, lordship, this Lafarge Mining Limited versus Union of India, your lordship, the Honorable Court have accepted the doctrine and applied the same in that case, your lordship. They stated that the Honorable Court have acknowledged and duly applied the doctrine of margin of appreciation in the case of environmental conflict, your lordship. The present doctrine works in the favor of the government where due procedure has been followed by authorities. However, the project is in conflict with the environmental rights of your lordship. In the present case, as mentioned, due procedure has been followed, and it is not contended that the due procedure was not followed, your lordship. Therefore, this doctrine is to be applied. It is humble request of the council, your lordship, that this doctrine is to be applied by the honorable bench, your lordship. Furthermore, your lordships, the contravailing public trust, as mentioned in the memorial of the petitioner, they have said the public trust doctrine has been violated, your lordship. However, lordship, if you refer to page 95, para 35 of the compendium, it states where a commercial venture or enterprise would bring in results which are far more useful for the people, difficulty of a small number of people has to be bypassed. The comparative hardship have to be balanced, and convenience and benefit to a larger section of people has to get primacy over the comparatively less hardship. As mentioned, Your Lordship, the protest is being committed by the half of the population of Aryavata. However, Your Lordship, half of the population is in favor of the development, and the nation as collectively is in favor of the development. Your Lordship, that it will boost the economy of the nation as whole, not only the Aryavata. Your Lordship. Furthermore, Your Lordship, precautionary principle and polluter spray principle is not applicable in the present case, Your Lordship, as has been stated by the petitioner. Your Lordship, precautionary principle is applied in the cases where a new development is to be conducted, which is scientifically not possible to assess what damage it will do to the environment, Your Lordship. In the present case, if Your Lordship may refer to para 3 of the Mood proposition, it says dams, roads and railway tracks are to be constructed, Your Lordship. None of these are newly scientifically development, and the government has not claimed that these are newly scientific developments, and the proper environmental assessment has already been conducted by the Joint Committee, Your Lordship. Furthermore, Your Lordship, polluter pay principle, as stated in the MC Mehta case, these are factories, Your Lordship, leather factories, trainees in the Uttar Pradesh. That was the case in MC Mehta, Your Lordship. They were polluting Ganga. The pollutants from the trainees, that are the factories, leather factories, they were going into the river Ganga, Your Lordship. That's why the court said the safeguards are to be protected. However, they did not close down the factories. It is important to know, Your Lordship, the factories didn't close down. Only a safeguards were provided that the pollutant should not flow into the river Ganga, Your Lordship. That is in the present case, Your Lordship, the railway track, roads, bridges does not cause pollution, Your Lordship, afterwards. And Your Lordship, that is why the polluter pay principle is not applicable in the present case, Your Lordship. Furthermore, Your Lordship, in the present case, Your Lordships need not to assess or warrant the decision of the expert body, Your Lordship. If Your Lordship may kindly refer to page 76, paragraph 14, it is stated that by your honorable court, in our view, the development plan which has been finalized after taking recourse to the statutory provisions and the undergoing rigor thereto cannot be stalled in entirety, thereby putting the entire development activities to a standstill. In addition, and Your Lordship, in Narmada Bachao Andolan, it was stated that the court should refrain from being asked to review the decision just because a petitioner is filing a PIL alleges that such a decision should not have been taken because an opposite view against the undertaking of the project, which view may have been considered by the government, is possible. Your Lordship, the doctrine of public trust, public policy, the doctrine of public policy is applicable in the present case. Lordship, the act of the government, prima facie, are for the benefit of the population as well, Your Lordship, and the due procedure has been followed. The permits were duly given by the authorized authority, Your Lordship. Therefore, in the present case, Your Lordships are need not to inquire further into the merit of the case, Your Lordship, as the precedent set by your own honorable court is applied in the present case, Your Lordship. Furthermore, Your Lordships, the counsel for the respondent have pointed out the counsel apologizes, Your Lordships. The counsel seeks a minute for the water. Counsel is number 5, Your Lordships.
You are not seeking the permission to take the order.
I asked Your Lordships, and the counsel sincerely applies, Your Lordships, for not doing that. Further, Your Lordships, international conventions are in favor of the government, Your Lordships. In the present case, ICCPR, that is the International Covenant on Civil and Political Rights, permits development which are justified and reasonable, Your Lordships. Your Lordships, as mentioned, the laws of Republic of Kabul are pari-materia to law of Republic of India. That is, Your Lordships, the Federal Democratic of Kabul is signatory and has ratified ICCPR in the present case, Your Lordship. Your Lordship, it provides that it is a duty, regardless of the political, economic or cultural system, to promote and protect all rights and fundamental freedom, Your Lordship. That is why, in the present case, Your Lordship, as mentioned, 9,800 acre of land cannot be compared as how much land is being acquired. Lordship. The geographical boundaries of Aryavarta could be same as of Uttar Pradesh or as of Rajasthan. Lordship. And this is in favor of the government, that the government has rightly chosen the area, as dams could not be constructed anywhere. Lordship. And your Lordship, the honorable Lordships have in past as well never stopped development projects. Lordships. They have provided safeguards, however, in majority of cases, your Lordships, 9 out of 10 cases, they have allowed the development as it is necessary for the nation to further, in furtherance of development, your Lordships. In the present case, all the safeguards in the present case are being adhered by the Joint Committee, your Lordships, as mentioned in the Moot Proposition Para 8. And all the guidelines, your Lordships, the emphasis is applied on the all guidelines are being adhered for the minimal environmental impact, your Lordships. And furthermore, the same has been stated in Vienna Declaration and Program of Action, your Lordships. Again, India is signatory to the same declaration, so is Pagul is also a signatory to the same, your Lordships. In the present case, Pagul's right to development provide a reasonable and objective justification to safeguard the right of whole population. The Council understands the paucity of time, Lordships. The Council will summarize the arguments for the issue 1 and issue 2, or A or B, as mentioned in the Moot Proposition, your Lordships. With this Council will just summarize the submissions that were present, that the present PIL is not maintainable because Elon Musk had not exhausted alternate remedies available under the NGT Act, lack of local standard and bona fide intent, as Elon Musk PIL is motivated by personal and political interest. Your Lordship, if you may refer to Para 9 of the Moot Proposition, and the same has been stated by the petitioners, that Elon Musk is a research scholar in PITA, that is the Pagul Institute of Technology in Asgard. He is a learned, educated person, Your Lordship. What he does is that he jumps to the conclusion and starts a protest, Your Lordship. At the stage where he consulted the Joint Committee, and where the Joint Committee stated that the due process has been compiled with by the Joint Committee, and there are no right has been will be apprised. Your Lordship, the present status of the development is that no development has been started. It is only a proposed development, and the research is going undergoing in the present as of the date, Your Lordship. And what Elon Musk do is that he started a protest, a provocative protest, which led to a situation where casualties happened, public property was destroyed. Section 163, that is curfew, Your Lordship, of PNSS, has to be applied by the district magistrate, Your Lordship. The same has been stated at Moot Proposition Para 10, Your Lordship. The situation was so grave, Your Lordship. Again, the preemptive detention, or Section 170 of PNSS, where the district magistrate applied the same, because to restrict individuals who may commit cognizable offences, Your Lordship. And they were detained. Further, Your Lordship, then FIR was filed against Elon Musk, and the case has made out as he was convicted and is behind the bars as of the date, Your Lordship. Furthermore, Your Lordship, that the present instance does not warrant assessment of Section 150. Your Lordship, going behind the door and violating the basic spirit of public interest litigation. Your Lordship, in Hussain Ahmad Khatun case, which is considered the origin of public interest litigation, the petitioner came before the Honorable Court in the plight of the undergoing under trial prisoners who could not have raised their voice before the Honorable Bench. Lordship, the public interest litigation provides a person whose right has not been violated to come before the Honorable Court to contest a trial for those whose right have been violated. In the present case, Your Lordship, Elon Musk is himself who is being convicted, and no other person's right has been violated by Section 150, Your Lordship. Therefore, it is a personal interest litigation, not a public interest litigation, Your Lordship. Furthermore, Your Lordship, in the present case, the development project is insustainable in nature. Judicial interference is not required in the present case, and the government of Pagul has not violated its international obligation. The Council seeks permission to call upon the two councils for the submission of issue 3 or C, as mentioned.
Before you leave, I have a question. Section 152 and 124 AIPC are analogous. Okay. And the constitutional validity has already been upheld by the Supreme Court of India for 190. So the Supreme Court has clearly said that nothing less than an armed rebellion against the government would be considered as sedition. So what material do you have against this gentleman? Did he raise arms rebelling against the government? Because in case you say they are paramateria, so then you will have to meet out with this argument. You have this ingredient with you before you charge this section. What was the material before?
The council understands also. However, in Bengal immunity case, it is stated if an enactment is repealed and reenacted in its origin state, in the present case, Article 120, the Section 124A of the erstwhile IPC and the present PNS, the section is not reenacted, the words are changed, and in the part where in the thereafter, where it is mentioned that which section is comparative to the erstwhile IPC, against section 152, no section has been mentioned, Your Worship. In the present case, Your Worship, the session code has correctly convicted Elon Musk. That satisfies the mens rea and actus reus, Your Worship. There is a chain of link in the present case, Your Worship. On 10th, the Elon Musk started a protest, Your Worship. On 14th, he gave a provocative speech, Your Worship, which led to a photo. The pledge with thousands of people that they will not in any way let the implementation of the development project, Your Worship. Furthermore, Your Worship, this led to the casualties and the destruction of property, Your Worship. This is a social unrest that has been caused, Your Worship. Your Worship, the co-counsel will further elaborate on this issue, Your Worship. The prime case is made out and session court has rightly convicted. And no appeal, Your Worship. It is not an appeal that has been presented before, Your Worship. It is a constitutionality of section 152. If Lordship, the case was not made out against Elon Musk, he could have filed an appeal before the Honorable Court or High Court, Your Worship, for that matter, that the High Court, for the counsel apologizes for the hierarchy of the court. Appeal could have filed in the appellate court, Your Worship, that the charges are wrong, Your Worship. However, in the present case, what Elon Musk did, that he jumps the gun and approached from the back doors of this honorable court, violating the natural justice and the spirit of public interest litigation and the law prescribed by the honorable court itself. That is why the present case has been, the present case is not maintainable, and the acts of Elon Musk are rightly being convicted under section 152. If the Lordship is satisfied, co-counsel will further elaborate on the question. Much obliged.
Lordship, Council seeks permission to approach the text. Much obliged, Your Lordship. Lordship, the Council seeks permission to speak without the much obliged, Your Lordship. Lordship, the Council will be dealing with issue 3 or C as mentioned in the moot proposition. Before proceeding with the issue, with Your Lordship's permission, I would like to bring to Your Lordship's notice certain facts that were misled by the counsels for the petitioner. Lordship, in para 9 of the moot proposition, it is mentioned, and I seek permission to read it out to Your Lordships. Lordship, on 10 July 2024, Elon Musk started a protest campaign with the Janata Morcha Youth Wing team in front of the PITA campus against the government in power. Lordship, the protest was joined by many students and scholars of PITA as well as residents of the city of Asgard. During this course, Elon Musk made a, Your Lordship's emphasis is added on the next two words, that is, Elon Musk made a public provocative speech on 14 July 2024. Lordship, in the course of his speech, he mentioned that the policies of the Pakistan government pose a significant threat to the environment, biodiversity and livelihood of the indigenous tribes. Lordship, he then took a pledge with thousands of protesters of Asgard not to allow this project to be implemented. Your Lordship, it is further mentioned that this caused a furor leading to a law and order situation which resulted in casualties and damage to properties. Your Lordship, there were casualties and there was damage to property. Your Lordship, the counsels for the petitioners mentioned that there is right to protest which cannot be contested by the counsel for the respondent, but that right is regarding peaceful protest only, Your Lordships. That right is not regarding protest which causes casualties and damages, Your Lordships. Lordships, the counsels for petitioners have also not assessed how section 152 is unconstitutional. They have only mentioned the facets on which they could be, the assessment could be made, but they have not themselves assessed how the unconstitutionality of section 152 is to be established. Lordships, further, before beginning with my submission, the council seeks permission to state certain arguments in this regard. Lordship, there is a presumption of constitutionality that vests with every enactment post the constitution of Parliament was enacted, Your Lordships. Your Lordships, this presumption of constitutionality is the first bar to the scrutiny that could be made about the constitutionality of a provision. Your Lordships, in the case of PUCL versus, I apologize for the mistake, Your Lordships, in the case of Saurabh Chaudhary versus Union of India, it is a 2007 judgment. Your Lordship, it was mentioned that when there is a presumption of constitutionality, the scrutiny phase could not be started before maintaining that there was prima facie unreasonableness and Article 21 of the Constitution is violated. Your Lordship, the counsel for the petitioners have not argued that Article 21 of the Constitution of Kabul has been violated via the provisions of Section 152 of PNS, Your Lordship. Lordship, further, they have also not maintained that how prima facie section is unreasonable, Your Lordships. Lordships, if Your Lordship permit, I would begin with my submissions in this regard to show actually how Section 152 does not fail the test of constitutionality with regard to Section Article 19(2), Your Lordship. That is reasonable restrictions that could be put. I would also like to bring to Your Lordship's notice that while arguing the issue 2, that is whether right to environment would prevail or right to carry on trade and profession and occupation would prevail. Your Lordship, the counsel for petitioners have mentioned the reasonable restrictions under 19(6), but they have intentionally avoided the restrictions that are mentioned in Article 19(2), Your Lordships, regarding the restrictions that would be put on right to freedom of speech and expression, Your Lordship. Lordships, if you permit, I will begin with my submissions in this regard. Much obliged, Your Lordships. Your Lordship, the counsel submit two arguments on this issue. Firstly, that Section 152 of PNS is valid since it comes within the saving clause of Article 19 of the Constitution, and secondly, that it is legal, the section is legal, legitimate, and proportionate under the ICCPR. Your Lordships, ICCPR is enforceable in the state of Kargil, as it was mentioned in the case of PUCL versus Union of India. It is a 1997 judgment, Your Lordships. Your Lordship will find the judgment in the additional documents that have been provided with the compendium. Your Lordship, may I proceed? Much obliged, Your Lordships. Lordships, in Bengal immunity case, as my co-counsel has already mentioned, it is a 1955 judgment. Your Lordship may refer this judgment on page 53, para 3 of the compendium, Your Lordship. It was held, and I quote, that it is a well-settled rule of construction that when a statute is repealed and re-enacted and words in the repealed statute are reproduced in the new statute, they should be interpreted in the sense which had been judicially put on them under the repealed act. Your Lordships, because the legislature is presumed to be acquainted with the construction which courts have put upon the words, and when they repeat the same words, they must be taken to have accepted that the interpretation put on them by the court as correctly reflecting the legislative mind. Your Lordships, in the current case, words have not been reproduced. The Section 124 of erstwhile IPC and Section 152 of PNS are entirely different, Your Lordships. The pith and substance in the presence of the authority of Bengal immunity case does not stand, Your Lordships. Lordships, without prejudice to this argument, the counsel makes the submission that Section 152 of the PNS is valid since it comes within the saving clause of Article 19 of the Constitution. Lordships, Section 152 of the PNS falls in at least 3 of the restrictions set out in Article 19(2), that is, of public order, national security, and incitement to an offence, Your Lordships. Your Lordships, it is humbly submitted, and Your Lordships may refer this case on page 60, para 22 of the compendium, that actions that cause public disorder or disturb the prevailing public tranquility undermine national security. Your Lordships, in the current case, there was public disorder that has been caused by the provocative speech that Mr. Elon Musk, the petitioner, has given, and there were casualties and damages because of that. Your Lordships, the mens rea is not questioned because the Sessions Court has already convicted Mr. Elon Musk. So it is to be presumed that there was mens rea to cause public disorder, and such is caused by the provocative speech of Elon Musk, Your Lordship. Your Lordship, further, the words in section 152 are endangers sovereignty, unity, and integrity of Your Lordships. Your Lordships, I submit that because of the authority of Brij Bhushan case, the public order that has been disturbed undermines the national security, which falls within the phrase that endangers sovereignty, integrity, and unity of India, of Parliament, Your Lordship. I apologize for the mistake. Your Lordship, section 152 penalizes endangerment of unity and integrity, and it seeks to prevent an act against the society and is constitutionally valid as it is reasonable restrictions on right to freedom of speech and expression. If your Lordships are satisfied with my submissions, I would like to proceed with the next submission. Much obliged, Your Lordships. Lordships, in the next submission is that section 152 of PNS, that is Pagil Nyaya Sanhita, is legal, legitimate, and proportionate under ICCPR obligations, Your Lordship. Your Lordship, the right to freedom of expression under Article 19 of the ICCPR, Your Lordship, Article 19 of ICCPR has been provided with additional documents of the complainant. Your Lordship, it is not absolute. Your Lordship may refer the ICCPR as has been provided. Your Lordship, under ICCPR, a restriction to such a right, that is right to speech and expression, could be lawful if it is prescribed by law, if the provision or the restriction pursues a legitimate aim, and Your Lordship, if it meets the test of proportionality. Your Lordship, the first submission in this regard is that the law is prescribed by the legislature, Your Lordship. Your Lordship, the law is founded in domestic law, in the PNS, where Act you will find 152, it is easily available to the general public. Your Lordship, secondly, it is duly published, and thirdly, that it meets the test of forcibility. Your Lordship, the provision clearly establishes that acts which would endanger the sovereignty, integrity and unity of India would be penalized. Your Lordship, there has been an explanation also provided with the section that reads that this appropriation of government policies and administrative actions would not fall under this provision, Your Lordship. So, however, harsh speech regarding the policies of the government, it would not be covered under section 152 of PNS, Your Lordship. So, there are enough safeguards in this regard, and the section is not vague, Your Lordship. Your Lordship, further, I submit that section pursues a legitimate aim, that is, of maintaining public order, Your Lordship. Your Lordship may refer Article 38 of the Constitution. Your Lordship, I seek permission to bring Constitution. Much obliged, Your Lordship. Your Lordship, Article 38 reads, state to secure a social order for the promotion of welfare of the people. Your Lordship, in IR Polo case, that is a 2007 judgment, it was held that when there is a conflict between a fundamental right and a directive principle of state policy, the balance could be tilted towards the directive principle in cases where public interest is involved. Here, Your Lordship, maintaining social order is necessary. Your Lordship, I seek 1 minute. Your Lordship, public order entails that there must be general condition that must exist for individuals to enjoy their rights and freedoms. Your Lordship, in the present case, the government is entitled to enact such provision under Article 38 of the Constitution, and as held by the authority of IR Polo case, this could curb the fundamental rights as guaranteed under Article 19 because there is public interest involved in this provision, Your Lordship. If Your Lordships are satisfied, I would move on to the next submission in this regard. Much obliged, Your Lordships. Your Lordships, section 152 of PNS meets the test of proportionality. Your Lordships, the punishment that has been given in this, that has been prescribed in this provision is imprisonment of either 7 years, imprisonment of life, or imprisonment that may extend to 7 years or fine. Lordships, there has been ample discretion provided to the judiciary to grant discretion provided to grant punishment with view of the graveness or the seriousness of the matter, Your Lordship. There has not been provided a minimum requirement or a minimum punishment that has to be given, Your Lordship. From 1 year to 7 years or even less, the punishment could be given keeping in regard the graveness of the offence, Your Lordship. So, Your Lordship, the provision passes the test of proportionality in this regard as well, Your Lordship. If the Lordship is satisfied, I would like to move on to the prayer. Your Lordship, I will complete and then the rebuttals will. Much obliged, Your Lordship. Lordships, in the light of the facts of the case, issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully requested that the Honourable Court be pleased to declare that the writ petition is not maintainable under Article 32 of the Constitution and declare that the right to environment will not prevail over the right to carry on trade and profession in this instance, and declare that Section 152 of PNS is constitutional, and or pass any other order as the court deems fit in the interest of equity, justice and good conscience. For this act of kindness, respondent shall be duty bound forever, all of which is most humbly and respectfully submitted. I rest my case, Your Lordship. Much obliged, Your Lordship.
So this is the whole argument of the both sides. The counsel, it is not maintainable because the petitioner comes before this court in personal capacity or the public capacity that in this regard the petition is not maintainable. This is whole argument. Yes.
Council seeks permission to start with the rebuttals.
What is the maintainability? Because you are coming before the court the personal capacity, not the personal public capacity. How can the petition maintainable?
Council seeks
That is right.
Your Lordship, in the present case, the petition that is launched as a file of PI in the Supreme Court for challenging the constitutionality of Section 152, whereas challenging the scheme, and hence as the Supreme Court is the protector and guarantor of the fundamental rights, that's why he has approached the Honorable Supreme Court. Council seeks permission to start with the rebuttals. Your Lordships, the respondent in the arguments have mentioned the fact that the petitioner, that is Elon Musk, is personally motivated and a political person. Does this mean that merely being a president of Janata Morcha party gives him a mala fide intention to file a PIL? Rather, it can be contended that being the president of Janata Morcha party, he is diverted, he is connected with certain sections of the society, and he is much interested in the interest of the general public. So hence he has a bona fide interest in filing this PIL. Moreover, Your Lordship, the council have in their contentions throughout talked about approaching the NGT. But as the council already contended that Supreme Court is the guarantor and the protector of the fundamental right, Article 32 is itself a fundamental right, and hence there is no need to exhaust the alternative remedy before approaching the Honorable Supreme Court. Moreover, Your Lordship, in the present case, the constitutionality of Section 152 was to be reviewed, and hence the petitioner has approached the Honorable Supreme Court. Moreover, Your Lordship, in the present case, the construction which requires 9,800 acres of forest and dry land. Forest means on that particular area the wildlife resides. Wildlife means the animals that live on that particular area. But according to NGT Schedule 1, the 7 points under which a person can approach NGT does not deal with wildlife protection, and hence the case of approaching NGT do not
This is
stand.
not the personal capacity. This is not the personal capacity.
Indeed, Your Lordship, it's not the personal capacity, but while challenging the constitutionality of Section 152, it can be stated that that's where the petition has approached the ground. Moreover, Your Lordship, the respondents in their contention have stated a line that mere fundamental rights are violated. Are the fundamental rights mere? They are not the mere. They are challengeable before the Honorable Court. Under Article 32, before this very bills, fundamental rights are very important for the sustenance of for a person, and they cannot be held as mere. Furthermore, Your Lordships, the respondents have mentioned that they have went through the EIA process. The fact sheet is totally silent about this thing, that whether EIA process was taking place or not. In the fact sheet paragraph, it is written that they merely asserted that they have been through they have taken all the guidelines. This asserting means strongly believing, clarifying the fact that they have shown all the proofs that are necessary to be taken in this particular case. And also in the whole fact sheet, it is nowhere written that the EIA process was taking place. And also, Your Lordships, they have contended that Article 21 can be restricted by the procedure established by law. And here the council would like to ask them that what procedures established by law are they asking about? Is it EIA? Then EIA is nowhere mentioned in the fact sheet. Then how can they say that it took place or it not? Moreover, Your Lordship, they talked about the intention and purpose of Elon Musk in doing also. Your Lordship, if Elon Musk would have any modified intention behind doing this, then why would he have approached the joint committee at the first place seeking for why they have introduced such kind of a scheme? Why would have spread awareness to the citizens, asking them and telling them that the scheme introduced by government is impacting the environment? If he was having any modified intention, then he would not have done any such kind of things and he would have directly jumped to the protest. Hence, it cannot be contended that he had any modified interest. Moreover, Your Lordships, in the present case, the public violence and disruption to the casualty which took place was caused by the third party. It was unforeseeable, it was unpredicted. It cannot be contended that Elon Musk intended to cause such kind of anything. Does it mean that if third party create any such situation, one's fundamental right to protest will be curtailed? And moreover, Your Lordship, where the council contention is the protester which caused such kind of violence were detained for 8 days. And after the 3 days, Elon Musk was charged of section 152. Whereas section 152 always talks about public order. It talks about overseeing the government. Does there anywhere in the arguments talks about superseding the government? No, Your Lordships. Moreover, Your Lordships, they are arresting Elon Musk after 3 days of the detention and charge sheet against him is more of a political purpose of the government. Elon Musk is the president of Janata Morcha party, which is in the opposition of the current ruling party, and the council thinks that charging him against section 152 is their political purpose. Moreover, Your Lordships, the respondents throughout their case have talked about the development. They have talked that development is throughout the country. But what about the right of the tribals? Just because the tribals are underprivileged, does it mean that they cannot voice their concerns throughout this honorable bench? And Your Lordships, just because the tribals are underprivileged, they have many special sections. The Constitution itself talks about the Constitution. Talks about the special rights of the minorities. Article 29, Article 224, Article 342, Schedule 5 and 6, Article 323A. These all the articles of the Constitution talks about the rights, talks about the minority section. So does it mean that giving development means superseding all of the rights which are mentioned in the Constitution itself? What about the development of the tribal? What about their happiness? Giving happiness to others means superseding the tribal's right? Moreover, Your Lordships, the council in the contention have put forward the ICCPR thing. They have talked that the laws of regular perimeteria to laws to India. But Your Lordships, India is a signatory with ICCPR is a fact, and in the fact sheet it is written that the facts are not, that the fact in the fact sheet it is written that the laws of regular perimeteria to the India, facts of the regular are not perimeteria to India. How can they contain the same? It still remains a question. Moreover, Your Lordships, the councils in the contention have put forth the issue that there is always a presumption of constitutionality if the issue is proved. Does it mean that no one has a right to approach the court and approach for the judicial review of any kind of scheme or law or anything? Presumption of constitutionality means that the particular issue is always right. Don't the court have any right of judicial review, and under the Constitution itself they have a right of a judicial review?
Please tell us one thing. You are a student. So when you file this PIL, would you not have filed a PIL to the effect to stop this project? Instead of filing a PIL to challenge the question of the uncertainty, why did you not choose to file a PIL questioning this entire project? Instead of filing a PIL for questioning the validity of 150, you were a student. When you convene a meeting, joint meeting, and you realize that the government won't stop, then why did you not file a PIL questioning this project?
Your
What
Lordship,
stopped you?
Your Lordship, in the present case, the fact also is written that when that Elon Musk got to know about that the scheme is going to be implemented and the memorandum of understanding has been signed, he tried to approach the joint committee and ask about it. Maybe it could be the point that he must have not gotten any affirmative answer from that particular committee. And then the only option left for him was of the protest. Protest is a fundamental right. It can't be curtailed. And
Why
that's
prior to protest you did not file a PIL? That was a fit case for PIL. The court would have examined. Merely signing the MOA would not restrict the court. You should have filed a PIL questioning this project. All these things the court would have seen.
indeed, Your Lordship, but as in the fact sheet, in the fact sheet as it is written, they have dealt with all the problems, so we have to deal with this. Thank you.
The counsel for the respondents.
How can this
We
be
replied to those questions.
reply? Leading counted thereafter, this one,
Your Lordship, as the
additional after.
No, Lordship. The answer to those questions, Lordship, that was the first the petitioners will argue that it is respondent, then rebuttal.
Nearly 3 stages,
Four stages, Lordship.
4 stages.
Here the court officer will
Then the additional argument is there.
No,
New argument is there. Then you are purple.
Your Lordship's new arguments they have not talked about ICCP as the investigation. That is why some counsel. Much. The procedure goes that 4 rounds to be conducted. Much of that, Your Lordship. Your Lordship, many questions are to be put before the respondents. Your Lordship. First, that section Article 32 itself a fundamental right. Your Lordship, we do not contest that it is a fundamental right. Your Lordship, as mentioned, that if Your Lordship allow this public interest litigation, there are 2 facets to the present case that is not disputed, Your Lordship. First is environment, and second is the constitutionality of Section 152. We put forth 2 contentions, Your Lordship, in our opinions. First, Section 152 is not maintainable because it is a personal interest litigation that has been accepted, Your Lordship. Second, Your Lordship,
Please read 152.
counsel this position. The whole section, Your Lordship? Yes. Whoever purposely or knowingly by words either spoken or written or by signs or by visual representation or by electronic communication or by use of financial means or otherwise excites or attempts to excite succession or armed rebellion or subversive activities or encourages feeling of separatist activities or endangers sovereignty, unity and integrity of India or indulges in or commits any such act shall be punished with imprisonment of life or with imprisonment which may extend to 7 years and shall also be liable to fine. Explanation. The comments in expressing disapprobation of measures or administrative or other actions of the government with a view to obtain their alteration by lawful means without exciting or attempting to excite the activities referred to in this section do not constitute an offence under this section. Your Lordship, in the present case, as mentioned, in the Bridge Motion case, social order, when it is hampered, it endangers the sovereignty, integrity and unity of India. Your Lordship, mere protest is not we contest, is wrong. It is well protected under Article 19. Your Lordship, if I may bring to your notice the farm protest, Your Lordship. Honorable Supreme Court held that a peaceful protest is allowed. However, Your Lordship will recall that if the protest goes out of the hand, it is unlawful, Your Lordship. Sedition charges were also brought before the Honorable Court against the protesters, Your Lordship. Your Lordship, it is well settled that the social order is to be read in this section, Your Lordship. Furthermore, I'll answer the other questions which mentioned by the petitioners. As mentioned, Your Worships, as the Honorable Court is already overburdened, the second facet, that is the environment. The counsel for the respondent do not contest that there exists a public interest in the environmental matter. However, Your Worship, there is an alternative remedy, and it is stated by Honorable Court itself, and there is an effective alternate remedy. The petitioner should approach there first. Your Lordship, there are ample jurisdiction of the National Green Tribunal, which is effectively there to address these questions of environment. Your Lordship, tribal rights arise out of the right to environment. Their rights are Your Lordship, overlap with the rights of the environment. Your Lordship, if you may refer to Schedule 1 of the NGT Act, it provides certain legislatures against which litigation could be filed in the NGT. Your Lordship, it mentions the Environment Protection Act of 1986. That is an umbrella legislation, Your Lordship, covering all the matters related to the environment. Your Lordship, tribal matter, even though a fundamental question does arise of the environment, Your Lordship, and it can be rightly be dealt by the National Green Tribunal, as also did in the 2023 case that has been mentioned by the respondents, Your Lordship, a very recent case, Your Lordship. Furthermore, Your Lordship, the petition stated mere fundamental rights. No, Your Lordship, we mentioned mere legal right, which they mentioned the Forest Right Act, which is also not absolute. Your Lordship, they mentioned Section 3. Section 3 is already curtailed by Section 3, subclause 2, Your Lordship, which empowers government for construction of certain, Your Lordship, there is numerous pointers that have been provided in subclause 3, which curtails those rights enumerated in Section 3 of the Forest Right Act. And the Section 14 of NGT Act provides that NGT is empowered to entertain all the legal right matters that arise of the environment, Your Lordship. Again, the PIL should not have been filed here, but separate litigation should have been done in the NGT, Your Lordship, which could have provided faster remedy, as claimed that the Ilonras is well aware of the law and order, Your Lordship, and aware about the rights, rights and private rights. Therefore, he should, as a reasonable man, should have moved to NGT for a safer, faster, and effective remedy, Your Lordship, and not approach the Honorable Court. Further, Your Lordships, the government, they have stated that nowhere it is mentioned that EIA is to be conducted. Your Lordship, the notification, environmental, the Ministry of Forest and Climate Change notification of 2026. If I may present it to Your Lordship, if allowed. The notification. Your Lordship, it reads.
See, don't repeat on the earlier argument.
Indeed, Your Lordship, indeed, we are answering those questions. It reads, list of project activities requiring prior environmental clearance. Your Lordship, it is statutory mandate to get prior environmental clearance. Your Lordship. It is stated in Rule 8, 1A, that any development activity, Your Lordships, development and construction projects, Your Lordship, development and construction projects are to be which certain square meters are given, Your Lordship. 1 acre equals to 4,042 meters square, Your Lordship. If it is multiplied by 9,800, it clearly surpasses the numerical limit that has been mentioned here. Therefore, and as we mentioned that permits were duly acquired, Your Lordship. It is not also not anywhere stated that the permits were arbitrarily acquired, Your Lordship.
What is this you are doing?
Your Lordship, it is the notification of the government, 2006 government notification, which provide for the environmental clearance. Your Lordship, it also includes the expert appraisal committee, constitution of expert appraisal committee, which approves projects, and later on ministry also approves, and later on the project is to be done, Your Lordship. Enough safeguards in this notification itself are provided, Your Lordship. Furthermore, Your Lordship, Lordship, they have stated that a third party, the casualties were third party, Lordship. It is a fundamental jurisprudence of criminal law. A man is liable for all his actions which he foreseeably can foresee, Your Lordship. It is a well-established property. Even though it is not stated, it has been evolved through a number of cases, Your Lordship. In the present case, when Elon Musk started the protest. The chain of action are important in the present. He is the son of eminent, the council apologizes for the speech of he is the son of eminent politician. He is also a president of the Youth Morcha. He started a protest. He does not goes to any authority, your lordships, any authority, be it NGT, be it High Court, and be it the Honorable Supreme Court, that why these actions have been taken. What he did, that he started a protest, which goes out of the hand. He being the leader of the protest lordships, who encouraged the population, thousands of protesters, who then led to the casualties. Your lordships, enough, the chain of action is well established, and the same has been considered by the session court lordships. That's why he is being conducted. Lordships may refer to para 11 of the moot proposition, which state the session court convicted Elon Musk and gave imprisonment of 7 years. Furthermore, your lordships, they have mentioned certain minority and tribal.
This time is there, your argument is over.
Time is over. 6 1 more minute, your lordships, conclude that. They stated that articles in the Indian the Constitution will protect tribal and minority rights. Lordship, those rights are related to scheduled tribes. Lordship. In the present case, these tribes are not scheduled tribes. They are indigenous and other tribes. Lordship, but they are not notified by the government that those are scheduled tribes. These section 342 empowers president to notify certain tribes to be scheduled tribes. In the present case, it is not the matter. It has been honored, arguably, on the bench.